terrorism, use of premises, and spoofing. It is understood that the Ministry of Science, Energy and Technology, I think Kadian is on, is to seek further clarifications from the Ministry of National Security regarding the disclosure of a key for protected computer to an unauthorized person and unauthorized disclosure of password or access code. And with that, we will continue today, the ministry will continue today to take us through the comments from stakeholders, starting at the proposed offense related to phishing. Member Gail, you concur with that summary, sir?
Yes, sir. That is what was done, and we had left off at the point of discussion in relation to spoofing. So right. I'm confirming that those were the contents of the deliberations.
All right. So thanks for that. We want to take the confirmation of the minutes of the meeting held on May 5th and any matters arising. I'm not sure if we want to take it now or take it at the end.
Well, we can take it now and just get that out of the way, sir.
All right. So can I ask for the confirmation of the minutes on May 5th? Obviously, I wouldn't be able to
So moved, Mr. Chairman.
Okay.
Seconded.
Thank you, Member Rodriguez, and seconded by Member Longmore. Is there any matters arising coming out of those minutes? Any member of the committee has any particular matter that they want to raise coming out of the minutes? All right, so it seems as if the minutes are reflecting very clearly what transpired during the meeting. That's good. All right, so we move to the matter for discussion, which is a continuation of the review of the Act. And I will...
Mr. Chairman.
Yes, member.
Sorry, but I in the last meeting, we were discussing the matter of spoofing, etc. And we're going to carry on that discussion this morning, as you have indicated. One of the things I would love to hear from the legal team here, given the NCB issue that is now before us in the country, and we've seen NCB has sent out videos, we have read in the media what's happening with spoofing, phishing. I would just love an understanding for myself, and I think maybe other members would be interested. How would the current NCB issues be related to this act, or vice versa, how this act would be related to help to penalize those that are currently doing the criminal acts against NCB customers, etc. I think it would be relevant for us to look at that analysis, because it's actually a case study right in front of us right now, and we can use it as an opportunity to see if this particular bill will be responsive to such issues. So I would really appreciate if we could just get something from them in terms of which section of the Act and how it could be applied, just to be sure that we have the necessary legislation to deal with such issues.
You are muted, Chairman.
Sorry about that. Yeah, no, I'm saying the very good point raised by the member, especially based on the timing of what we are discussing and, of course, what is actually transpiring in real time. Kadian, do we have members of the team that can address that, or would you want to pull together that for a specific discussion during the course of today?
Good morning, Chairman, again, and good morning, members. Let me, on record, apologize for CTD Murray, who is unable to be with us this morning. I noticed that we have online Lieutenant Colonel Godfrey Sterling. Perhaps Lieutenant Colonel may want to start off with bringing everybody up to speed with what is the NCB issue. that's currently facing the country. And then thereafter, we could have a discussion on the matter perhaps at another time, only to say that at this point in time, Chairman, as we note from what we have in the matrix, the ministry and the technical team is of the view that the existing legislation can in fact address what is considered to be phishing. But I would want Lieutenant Colonel perhaps to speak to it first, and then we can look at certainly how we have defined phishing or the common ways in which phishing occurs, which we actually have in our particular matrix, and then certainly looking at this current legal framework that we have that can address the different areas of phishing. So I'll hand over to Lieutenant Colonel first, and then I'll come back.
Thank you, Karian, for that. Lieutenant Colonel Sterling, you want to come in on this now?
Good morning, good morning to the members, and certainly to the other persons on the call. The NCB issue, as has been put in the public space by them through their Director of Special Investigations, Mr. Dean Nelson, really speaks to more than one type of cyber events that would have led to the clients losing the monies that were touted in the media, supposedly up to $23 million. Now, the first aspect of it seemed to have been a phishing campaign where the scammers actually sent email on media that looked like the authentic NCB emails. When this email was acted upon by the persons who were fleeced, they then had persons who were able to call these persons, which would be phishing, where they solicited the RSA tokens from these persons. Once they were in possession of the RSA token and the credentials that were entered pursuant to the phishing email, they then sought to give themselves control of the accounts, and then the transfers took place. Now, the specifics of the incidents are not known. Those are still the subject of the internal NCB investigation, vice the involvement of law enforcement. However, if you look at the two categories of cyber events, phishing would have sought to almost present a forged email from NCB. And so this is in line with the discussions that we've had, where the existing 2015 legislation and the discussion to date in this review would have positioned the legislation certainly in the new format to deal substantively with that. Phishing, on the other hand, is a little more nuanced, and I don't think we've dealt with it in any substantial way. And so as we seek to revisit or conclude the discussion on phishing, we have to treat with the corollary events, that being smishing, phishing, angular phishing, and spear phishing, which would seek to be also part and parcel of a coordinated phishing campaign. And so the act as it is now, as it deals with the presentation of fraudulent credentials, the soliciting of credentials from persons which are not necessarily being used for the purpose they're intended, as well as the ability of the scammers in this case to recognize whether or not it's current or past NCB modus operandi, which would have been sufficiently masqueraded to fool the account holders. It is something that we have not really touched on those nuances to date in these discussions. Chair.
Mr. Chairman, through you, thank you, Mr. Sterling. And I guess now the opportunity exists, especially for us to ensure that those matters that you just raised, the phishing and the smishing, we have to find a way to ensure that the legislation deals with those issues. And may I suggest, Mr. Chairman, if the technical team could put together some relevant clauses as it relates to this to ensure that we actually deal with this issue, that I think that would be quite important and relevant at the moment.
Fully agreed, member, and there's no better time than to take advantage of what has actually transpired to make sure that we are aware of the different types of activities and making sure that we have some kind of protection in there in terms of the response in terms of the act.
Chairman, may I ask Lieutenant? Sorry.
Just before you go, Senator Gill, please. Thank you so much. As a non-cyber person myself, if the team could just put together something, just a little paragraph on each of the issues, so that when we get the draft legislation, we can relate it. So, to explain the difference between phishing, smishing, and all the ings for us, it would certainly help us, to ensure that we're getting the best for this piece of legislation.
Absolutely.
Yes, Chair. I wanted to ask Lieutenant Sterling if whether to the best of his knowledge, these are situations where the customers in the first instance would have reported the attack. The institutions would have conducted their own internal investigations. And I make the assumption that they would also have some support from the security forces to conduct further investigations. And I would just want to have an understanding, because these occurrences are unfortunate events. It's not happening yesterday. They would have been happening for some time now. Whether or not there have been successes in terms of these investigations bringing the perpetrators to justice. To the best of your knowledge, Lieutenant Sterling.
Chair, through you to Member Gill, the success of such investigation would really be something that is not in the public domain, as by and large financial institutions tend to deal with these issues in-house and directly with law enforcement. However, when you look at the cases that MOCA and CFCD out of the JCF put before the courts, as well as those that the Office of the Director of Public Prosecution handled, and the fact that they have had successes in these cases, not knowing the specifics of those, one would have to say that where such cases are prosecuted, there have been some level of success, and certainly within the banks themselves, there have been some levels of successful remediation, because the audit trail that is left is one that can be followed, and it's just a matter of how the institution treats with it and the level to which the affected clients actually pursue the matter.
Mr. Chairman, if I could give some perspective from my career in financial institutions, what comes to public attention is just the tip of the iceberg. Most financial institutions, from a reputational perspective, prefer to deal with these fraud cases privately or quietly. And the truth of the matter is it doesn't allow a proper assessment of the scale of what is actually taking place. And I think, we should consider whether there should be some obligation for reporting, even in an anonymous way, say to, Bank of Jamaica, for example, so that we could see the aggregate figures, not just the ones that go to court or persons are charged, but we could see the aggregate scale. We could understand the scale of the problem. So I think it's something that, if not necessarily dealt with in this legislation, it could be a recommendation to the Bank of Jamaica, the financial, the FSC as well, to collect this data and then make it available to law enforcement and to the public on an aggregate basis.
Member Bunting, I appreciate and I can understand the reputational risk involved. And I would have raised it earlier when I think we're meeting with the JBA around the question of reporting. And I agree with you that the reporting needs to take place for us to have a feel, for us to have a sense of, how the magnitude of it, because it is the magnitude of it that we're going to use to inform ourselves, to make proper decisions as to how we treat with it. So I agree with you in terms of having some sort of an avenue for the reporting, because the reporting needs to take place.
Mr. Chairman,
I endorse that position, Chair.
I completely support what has been put forward by Member Bunting, and I'm just wondering if this legislation is the place it should go. I do believe it is the place, but I stand to be advised correctly on that. And if we could look at, if we agree that this is the right place, could we also ask the technical team if they could put forward some draft of what could be placed in here to deal with this specific issue?
I fully concur as well. Member Bunting's suggestion in relation to possibly to the Bankers Association or Bank of Jamaica, I think that should be pursued, because obviously we are only getting what comes out in the public domain, and as he's saying that the majority of the cases don't go, or they try to keep it as private as possible. And therefore you really don't get the full understanding of the magnitude and the amount and the frequency. So we will take that on board. Kadian, we'll take that on board, and we will have to make contact and try and get as much information as possible. Obviously, we'd have to treat it in a private, confidential manner. Obviously, as the hearings here are public. But yes, we can. That doesn't prevent us from getting the information to inform us properly. All right. Kadian?
Yes, Chairman. So perhaps on this matter.
Yeah, go ahead. Just conclude on this in particular, so we can move to the agenda item.
Yes, so Chairman, I was saying that if I'm to understand the members correctly with respect to this particular matter, I'm just going to reiterate what we have. Currently, the position of the technical team is that when we look at the different elements or the manner in which, or the ways in which phishing can take place, and look at the compendium of legislation that we have right now to include the Cybercrimes Act as it's currently worded, along with the Law Reform Fraudulent Transactions Special Provisions Act, we're of the view certainly that the activities referenced as phishing could be properly captured within the scheme of those legislation. However, I'm here in the committee to say that given what has happened with NCB, it's asking that we do one more look just to ensure that whatever it is that has taken place is in fact captured by what exists now. And I also understand Colonel to be saying that there may be perhaps a small smith of an area that may not yet have been addressed by the legislation that we'd look at. And the committee is also indicating that we may want to look at the potential for, or potential avenue for reporting of cyber incidents, whether within the scheme of legislation or another sort of scheme. And so on this particular area, we will then revert to the committee at the end.
There's one thing that I think is missing, and apologies if you said it and it has just slipped to me. We're also asking for the technical team within the ministry to just provide for the committee an outline as to the different types of phishing, schmishing, vishing, all of those, so that we have a grasp of the issues at hand.
Thank you very much, Member Campbell Rodriguez. I do have that noted. I actually was going to add that at the very end. I believe that was something that you wanted us to provide at the time when the legislation, and I may be wrong, when we are complete with the legislation, to ensure that when we look at the various definitions, we can match the sections, either of the existing law or the potential new sections that would have addressed those particular types of offenses.
Personally, I would prefer it before, that I can, because I'm not a cyber security person per se. So I'd love the time to read and understand and assimilate that information, so that when you come with the legislation, the draft legislation, I already have that understanding.
If I may, Mr. Chairman, through you, I'm going to agree with Member Rodriguez. But speaking for myself, I only knew about spoofing and phishing. I didn't realize that there were about 2 or 3 other kinds of inks, and the truth is, to the ordinary person, they kind of seem similar, but they are completely different offenses in law. Even when you look at what spoofing is versus what the phishing part is, etc., and the different ways that someone can be spoofed. Whether by a phone call pretending to be somebody else, or the email or the web addresses that are sent you to lead you to somewhere else, etc. So I definitely think it's important, if it is that we're to do justice to this new legislation that we are creating. Yeah, thank you.
Chairman, outside of that, I believe that the education to customers is important. And whilst we might not be able to put it in legislation, the banks have a fundamental responsibility to educate their customers against these occurrences. And so that is one of the things that I would want to strongly recommend, given these scenarios, as policy directives out of these financial institutions. I hope Member Bunting, who is a big banker, may agree with me where that is concerned.
Yeah, you're left out and lead from the front.
But though, Mr. Chairman, I'm in complete agreement with Senator Gale. But I'll tell you this, Mr. Chairman, I was following the NCB, I was following the NCB incident, and would you believe me that there were persons who actually said that it's somehow the government's fault. It's the government's fault because the government is pushing everybody online, and the government is talking about digital society and digital Jamaica, and everything should go online, and all the information and the brought in leads and everything else. And they said somehow it's the government. So whilst I completely agree that banks must have proper educational programs and sharing the wealth of knowledge with their customers, the truth is one of the things NCB has said is that we are completely tired of telling our customers, we will never ask you for this information. We don't need the RSA or RNA, something like that. We don't need it from you. We don't need the token information. We don't need the passwords. We will never ask for it. Persons are still freely giving this information to others. So what I would say is that whilst the banks do have a responsibility, and they must have a responsibility, and they should even give back the customers their funds, I don't know, but the government also, we should look at expanding, which I know we will as a part of our good governance structure, expand the knowledge base generally as it relates to how persons communicate or relate online generally, as we move towards becoming a completely digital society.
But Justice Chair, if I may, and just respond to that, and pardon me, because this is a particular area that, as a union representing bank workers, I have some concerns with. The banks have invested heavily in technology to be competitive, and they have been migrating their customers as a result of COVID and even before to utilize alternative digital channels. And that's a very good thing. but customers are going to be exposed because of the use of these digital channels. And remember, Terry Long, the government is only encouraging this direction, not pushing it, but encouraging it as a society, because it is the way to go. The Bank of Jamaica is going to amend their own legislation to treat with digital currency, and that is coming to Parliament. It is the way to go, but we have a responsibility through this mechanism to protect the customers and the clients who utilize the banking service.
Let me just say that the issue that Member Terry Long has raised is something that has gotten the government's attention. And so much so that I've had discussions with the Minister of Finance, because in order to be successful in moving to a digital economy, then you have to have the populace engaged in it. So the bottom line is that there's a lot that do not use technology now, and the bottom line is unless we get them on, then we're not going to have a successful transformation or transition. And therefore, there has to be a part of government doing a public education and public relation campaign sustained to be able to get those that are not currently using it to use it. So while the banks have a responsibility and other industries and sectors have a responsibility, the government does have an overriding responsibility to get the buy-in from the majority of the if not all of the citizens of Jamaica, if we are to have a successful transition. So that has not missed us, and the Minister of Finance himself has raised that with me. And of course, if he's so inclined, then obviously he's prepared to support it financially, which is the most important part. So just to let you know that that will happen.
Thank you, Mr. Chair.
All right, Kadian.
Thank you very much, Chairman. So I've taken note of...
Remember, Gail, just chair for me for 2 minutes, please. I'm just going to go separate from the computer for a second. Go ahead.
Sure, Chair.
Thank you very much, Chairman. So we have taken note of the committee's requests as well as the recommendation for inclusion in the legislation. And with that, we're going to move on then to the next topic. And so it was recommended by, MOCA and supported as well by the Ministry of Education that a new provision be considered in relation to cyberstalking. MOCA generally felt that we needed to address some crimes which are not either now addressed at all or not addressed in a full
Sorry, Mr. Chairman. If through you, Ms. Newton, can you remind me which of the documents we're working from right now?
Sure.
Which one of them is it? What's the title of it?
The title says General Stakeholders Comments, Research, Findings and Recommendations, Cybercrimes Act 2015, and I'm on page 19 of that. It
says General
Stakeholders Comments, Research, Findings and Recommendations.
You are on page 19 that speaks to the Ministry of Education, Youth and Information, cyberstalking of a child.
That's correct.
Thank you.
So as a sharing that MOCA mentioned the inclusion of a new offense of cyberstalking, and also the Ministry of Education sought to contextualize that particular offense in relation to cyberstalking of a child. This particular area was extensively researched by our colleagues at the LRD, and I'm going to now defer to my colleagues at the LRD to take us through the findings and their recommendations in relation to this particular area.
Okay, good morning. MTech has just taken us through the elements of the proposal regarding to stalking. As for our findings, we found that in the majority of the jurisdictions, save for the one that is referenced in the Ministry of Education's proposal, Ghana, cyberstalking is typically dealt with under the provision for malicious communications, which would be our Section 9. That section deals with using obscene, sending obscene, threatening, or menacing messages with the intention to harass. So that's a provision that is generally relied upon. We have looked at the Ghanaian provision, and we find that it is quite similar to the provision that we have for under the Sexual Offences Act as it pertains to children. And so we do not think that we need to amend the Cybercrimes Act to introduce this provision into the Cybercrimes Act, as we already have a provision of that nature. We also wanted to make note that there was a proposal when the Offences Against the Person Act was reviewed for the amendment of that act to make provision for stalking. And depending on the nature of that provision and the sentence that is imposed, that offense would also be prosecutable under the Cybercrimes Act by virtue of Section 4.
Any comments, members?
Mr. Chair.
Yes, member Turlow.
Yeah, sorry, not a comment on that, but just generally, could you remind me the forwarding of what do you call it? The forwarding of sensitive material, in particular material involving children, that has been a common feature. Some of it bordering on pornography, really. There's a case also in the Eastern Parish Court dealing with a matter involving persons forwarding things with children and so forth. And also just in terms of when we had spoken in some of the earlier meetings about partners sending pictures of each other, etc., in sort of revenge porn, etc. Could you remind me if we had finished dealing with that if we're finished dealing with that, and how we treat with persons who receive sensitive material and then proceed to forward them? Because I've seen where social media has in fact had to pull material that was extremely sensitive and bordered on criminal activity. And could you just remind me what was our final decision on that? I can't recall.
Katie, you recall that? You want to respond?
Thank you very much, Chairman. So let me start off with that. That Section 9, the existing Section 9, which deals with the use of a computer for malicious communication, that is a section under which we have treated all of these areas to address issues such as revenge porn, because those are areas that would deal with the type of communication, that's the type of communication. And so we had made recommendations in relation to addressing an amendment to Section 9 that would take into consideration some of what it is that you have requested, Senator. Member Terry Long, I'm sorry.
Yes, but what about does it include also when people are forwarding? Because again, when we spoke about public education campaign as it relates to the phishing and so forth, there's still too many Jamaicans who aren't aware that if you receive sensitive material, they just go ahead and they forward it in all the WhatsApp groups, they put it up on social media, all these things, and it's really like they oh, I'm seeing the notification with the video. I don't know, it's almost as if they don't know. Maybe we haven't done enough public relations campaigning, educational campaigning, but it's still happening very, very frequently. And if we look at the Ensure matter, that song Code by Briscoe, that had the children using the Ensure video, children using the Ensure to do several explicit acts, etc. It was being forwarded and forwarded and forwarded. So what are we putting in place in the legislation to protect our children and also that persons know that it's similar to revenge porn, and that this is, even if something comes to you, you should not forward it, because by forwarding it, you're actually engaging in a criminal activity. So how are we dealing with that particular matter, especially given what's happening now and this new TikTok craze? Because it's really the children in the case before Judge Maxwell, they said they didn't know what they were doing. They didn't know that it was pornography. They didn't know that it was bad. For them, it was just about doing a TikTok, getting a number of likes, and going viral for a week or 2 weeks. So I don't know. I mean, but we really need to embark on a big education campaign around these things, so that people actually know that it's criminal, what the offense is, and how are we treating with it that sort of forwarding and multiplication of these offenses. Because I'm unclear.
So I'm going to separate the issues that you have raised and start off by perhaps speaking to what may appear to be trite law, and I can be guided by the Solicitor General and the team at the AGC on this matter, that your ignorance of the law really operates as no excuse, no matter what age. And so that's where you use public education essentially to address those issues in relation to whether you do something that you didn't think was an offense or was something that was punishable by law and you do it. So that's that public education issue. Currently, if you're speaking to how it is that information is sent or transmitted, the legislation currently uses a very open term or generic term in Section 9, which speaks about use of, at the time it says, a computer to send it to another person. And so the sending will include your forwarding of information at the particular point in time. What was shared with us a while ago from the LRD was that the new Sexual Offences Act Section 9 actually mirrors a lot of Section 65 of the Ghanaian legislation. That legislation uses the word transmit, and transmittal takes place in a number of ways, shape and format, so it include as well forwarding. I perhaps will defer to my colleagues there to see whether or not that particular language, the word transmittal, is also reflected in Section 9 of the Sexual Offences Act, because if it does, then it would essentially deal with your transmission, whether forwarding on WhatsApp or any other means of material that is reflected there in material which, and I'm going to just repeat what the Ghanaian legislation has for the purpose of this discussion. When you transmit, publish, reproduce, sell by any physical description characteristics which identify information on a child, and it reflects a lot of what we have in relation to sexual grooming or legislation right now. And so that particular action would in fact be covered. What I would go on to say is that we perhaps would need to consider, and I'm not necessarily committee from a legislative perspective, we need to consider essentially looking at greater public education campaigns and through the ministry with responsibility for that. Because truth be told, when you put something in law, and it covers everyone. And whether you know, understand, or you're aware that this is actually something which is illegal is a different matter compared to say that the law needs to do something about it, because there's nothing that the law can do to make you more aware that this is in fact illegal other than using public education. So I'm just summarizing to say that I believe that, one, to address your issue, the law as it stands right now, as we intend to amend Section 9, as well as the other compendium of laws or Sexual Offences Act, seeks to deal with the transmittal of information of a sexual nature in a manner which is considered to be illicit or illegal, and that to the extent that persons are unaware that the law actually makes provision for this, this falls to a very strong public education campaign, more under the area of my word, cybersecurity, more than cybercrimes, to ensure that persons are aware that these actions are in fact illegal.
Okay, thank you. But could we add, because again, especially when we're dealing with young people and the minors in particular, their ignorance of the law is a little bit, I mean, whilst the legal principle is trite, I think we have to approach them with kids' eyes, literally. What I would add is, whilst the provision is generally stated, could we, given the age of technology that we're living in now, use language that they're familiar with or that the wider population is familiar with? So would it hurt if we added transmission by and include the various methods, whether it's by IG stories, WhatsApp, TikTok, what's the other one? Snap or whatever it is. I'm sorry?
No, I agree with you. So Snapchat has another option.
Right, Snapchat. So we could add, if it's not there yet, if it's not there, or if it's not being contemplated, would it hurt, instead of just saying distribution and via a computer or a device or a phone, etc., do we add the different means by which they're popularly distributed in Jamaica, which would be the WhatsApp, the Snapchat, the IG, the TikTok, and so forth?
So Member Turlong, and I'm not taking over the chair's role, but I do know my colleagues at the LRD would want to come in on this matter, and I would also defer to the CPC on this. But my understanding of how legislative drafting occurs is that you're not always going to be very specific about means of distribution, because if the means of distribution changes, if the name changes, if it is that they're added, then essentially you're going to have to be constantly updating legislation as technology changes. So we tend to use definitions or words that can tend to cover all means of distribution, no matter what it's called or how it evolves. But I'm going to defer to perhaps the CPC to indicate whether that level of granularity is something which the legislation could contemplate.
I see the LRD reps hand up. So we'll acknowledge her. Legal Reform Department?
Yes, Minister. We have just wanted to note that in relation to the concern raised by the member about the distribution of the images, that there is Section 4 of the Child Pornography Act that would address that, and it's written in broad general terms. It's not as granular as he was mentioning, for the same reason as MSET just mentioned, that you don't want to be that granular, because the means of distribution, transmission may change over time. And that's why it's written in that kind of broad language.
Okay, thank you for that clarification. CPC, wanted to come in?
No, Chair.
All right. I don't see any other hands. All right, okay then.
Apologies. So Chairman, with respect to Section 9 that currently, sorry, my apologies. So with respect to the issue of cyberstalking, what we're putting to the committee and what we would have heard LRD indicate is that the existing compendium of legislation would address the concern of cyberstalking and would address the concern of cyberstalking in relation to children as well. Let me, and I also wanted to add that I would have heard from our colleagues that the child pornography prevention legislation would also have addressed the concern that would have been raised by Member Terry Long. And so it's our recommendation that the committee not consider the inclusion of a new offense of cyberstalking in the manner recommended by either MOCA or the Ministry of Education, because the compendium of laws that we have at this time adequately address this particular issue.
Mr. Chairman, just a reminder that I hear what you're saying, Mrs. Newton, but we had a debate several weeks ago. No, I shouldn't have used but, I should have used however. We had a debate in this meeting a few months ago or a few weeks ago where we said, where the team is supposed to come back to us on the issue of whether or not issues relating to children, cyber crimes of any form relating to children should carry a higher penalty. And since the Ministry of Education was again talking about cyber stalking of children, I think that has to be discussed within that context. So I think when the ministry gets back to us on the issue, because if my memory serves me correct, and you are supposed to come back to us on the issue of that with further research, then we can take a decision, I think, on this issue. I don't think the two things could be considered outside of each other. And also in terms of section 9 that you referred to, I don't have my notes from section 9 here, but I remember that we had questions around the use of the words obscene and menacing in terms of how they are to be defined and is it a subjective meaning of them. So I think before we can sign off on whether or not we agree with the Ministry of Education's recommendation, we need to get the responses on those two things first.
All right. With your permission then, member, can I contextualize it? So recall that the particular offense which is being recommended is a new offense in relation to cyber stalking. And so we're indicating that as a discrete offense, there's no need for a discrete offense called cyber stalking because the actions which reflect cyber stalking are in fact reflected in legislation, different types of legislation or different pieces of legislation. However, if it is that the committee is suggesting that we need to consider that where the activities in relation to cyber stalking occur in relation to children, then penalties should be increased or the penalties should be greater. And that's a part of the research that we're going to come back to. Then we could perhaps agree that that is the area where we're going to come to, not necessarily to create a discrete section on cyber.
Correct. Correct. So, and also not just about the matter of children, but about the definition in 9A.
Right.
And the subjectivity of the terms menacing and obscene. So those two, I guess when you come back to us on those issues, then I know I would feel more comfortable as to how we handle this recommendation for cyber stalking. Because if it is sorted in 9, and if it is sorted with us agreeing for a harsher penalty when it relates to children, then there's no need to create an additional offense, in my mind.
Thank you, member.
Noted, member.
Minister?
Yeah, who's that?
LRD. We had just wanted to mention with regards to the concern expressed about the definition in section 9, that it is also being proposed that section 9 be redrafted, and it would be redrafted in such a way that those terms would not be included in it anymore, and to take care of the concerns that those terms have caused in terms of the use of the legislation. I'm not sure if that proposal was circulated, but there is a proposal to redraft the wording to take care of those issues.
Right, and it is, so what I'm saying is, I don't think I can, personally, I can agree to not accept the ministry's recommendation until I've seen that redraft of 9.
Well, but Ms. Newton, perhaps you could circulate that proposal to the members?
It was, if it is that you're speaking about the proposal that was circulated with the last set of recommendations, it was, but our understanding was that the member wanted us to come back in relation to section 9 specifically, and there are other recommendations that we have in this particular matrix, which also indicate that because of what's planned with section 9, it would make some of the other recommendations that have been made by stakeholders moot. And so we're going to just come back and just show the entire committee, having gone through all of the recommendations, how the new section 9 will address all of the concerns. So that's why I didn't raise it at the time. Because it's reflected in other things which are going to be raised later on today.
Mr. Chairman.
Go ahead, member.
Mr. Chairman, if I might, as you know, I've been playing catch up, and in reviewing the submissions of the various stakeholders before the committee, at which I would not have been present, I note the recommendations of the Office of the Director of Public Prosecutions in relation to this Section 9 offense. We're dealing here with the comments of MOCA and the Ministry of Education in relation to the crime of cyberstalking. But I want to raise it as I have reviewed it for the reason that the Office of the DPP is, as you know, uniquely positioned to advise us as to the usefulness of the legislation that we draft when it is necessary to prosecute an offense. And I find their comments on page 8 of their submission, which is dated the 3rd of May 2021, and I'm not sure when it was submitted to the committee, but I find it very useful that they take issue with the question of the definition of sending, with the use of some of the terms on this in section 9, obscene, and they make very specific recommendations as to how we can refine section 9 so as to allow it to be more easily prosecuted in the courts or more effectively prosecuted in the courts. And I'm not sure if we are giving consideration to the very significant and detailed recommendations, which also took into context or took into consideration the approaches taken in several other countries, including the UK, Canada, Australia, and other Caribbean islands.
Mr. Chairman, Senator Golden Campbell, what you're saying is what we discussed for that section, which is why they're rewriting it. All the points you have raised were some points that I'd raised about that section. Right. And I made the point at the time that when the DPP and MOCA make recommendations, we have to take them very seriously because of the work that they do. So that is part of the reason they're rewriting the section.
So all of this discussion that we're having now is for the revision of the provision for a later comeback. So we're not taking a decision on this today then?
That was my recommendation. I was saying to them, I don't think we should take a decision. That was my intervention. I don't think we should take a decision until we have seen the reviewed section 9.
I follow you, but I was understanding Mrs. Smith-Newton to be suggesting that we not accept these recommendations from MOE.
And I was saying we couldn't sign off on that recommendation until we have seen the reviewed section 9.
Thank you.
Because I would not be comfortable to do so. And also until we see what they come back with the research in terms of the recommendation that this committee made several weeks ago, that anything relating to children, any offense relating to children and cybercrime should have a greater penalty. So I was recommending that we not take their recommendation of not accepting what has been put forward until we have seen those two issues.
Chairman, I have found myself agreeing with Senator Campbell Rodriguez on that. May I please?
All right, noted. I don't hear any other member. So we take that. Adrian?
So Chairman, I just wanted to ensure that we're on the same page and we're clear. So in relation to section 9, and I know Senator, the member would have joined, Member Golden would have joined a bit, Golden Campbell, sorry, would have joined a bit late. But the committee did raise the issue of concerns in relation to section 9. The ministry did put forward as well suggested language in relation to how section 9 could be reconsidered. There is currently, as you would have heard from the team member at LRD, a consideration as to a redraft of section 9. And I'm just recommending, as I said earlier, that in relation to this matter, that when we have completed the look at all of the general recommendations, then we can go back to section 9, because other comments also reference the redraft of section 9 as addressing the concerns which have been raised. So may I move on, Chairman?
Sure, right.
Okay, thank you. So in relation to the next offense, MOCA would have recommended that the committee considers a new offense of cyber defamation. MOCA would have indicated that it did not feel that the existing legislation currently addressed this particular area.
Sorry, what page are you on?
I'm now on page 22.
Okay. Okay, thank you.
So the areas are not titled with particular headings, so it's just moving through recommendations. I'll indicate the pages as I move along for clarity. So on page 22, MOCA would have indicated that cyber defamation be considered to be a new offense, especially given the virtual world and the fact that persons can in fact be ridiculed and brought to have their particular, have themselves essentially lowered in the eyes of right-thinking members of society in the virtual world. Again, we would have asked our colleagues at the LRD to look at this area, and I'm going to ask the LRD to indicate its research findings and its recommendations in relation to this matter.
Okay, so our research findings have been shown that, that for the most part, the offense of defamation is decriminalized, and so it's handled in the civil realm. We only found 2 jurisdictions where there was provision for cyber defamation, one in Belize and one in the Philippines. And we know that the provision in the Philippines has been subject to constitutional challenge. We also note that as far as defamation is concerned, a deliberate decision was taken when the Defamation Act was passed in 2013 to abolish criminal libel. And so we think that if a provision is made for cyber defamation, that provision would be in conflict with the repeal of criminal libel, which is in Section 7 of the Defamation Act of 2013. And it could create an anomalous situation where I am guilty of, if I publish something on the internet, I can be prosecuted criminally for it. But if I did it in the print media, I would not. And that's an unlevel playing field, we think. And then what I could simply do then is just choose to publish in the print media where I'm only subject to a civil suit and escape criminal liability altogether. We think because of this uneven, this anomalous situation that could be created, it would be better to consider cyber defamation as part of a wider, broader discussion of whether or not defamation should be an offense simpliciter. And so we note as well that the Defamation Act is supposed to be reviewed, and it should have been reviewed within 5 years of its commencement. So the review is long overdue. And we think that in the discussion of that legislation, we think that is the context for this discussion of cyber defamation as part of that broader discussion as to whether or not defamation itself should be recriminalized.
Mr. Chairman, may I? Your mic is off. May I?
Sure, go ahead.
Right. I hear what is being said about the Defamation Act, but I don't take the point that what someone should do is then use print. Print is very expensive. So most of what is happening now is happening in the online space. And cyberbullying, cyberbullying is a very serious matter right now that is affecting a lot of people, and especially our young people and our children. And I think it would be remiss of us not to make this an offense. I really think so. And also, as you all know, I am very strong on my opinion that when MOCA and DPP make recommendations, they should be considered seriously. Now, if the Defamation Act is set to be reviewed, and we did not put it in the Cybercrimes Act, it means then that if this Defamation Act is reviewed next year or the year after, we would then be behind. While in reality, most of what is happening in terms of defamation right now is happening online. It's happening in the cyberspace. It's not happening in print. And so I think we have a responsibility to get ahead of it, and especially as it relates to cybercrimes. And I understand this situation of it being an anomaly, but as you said, that act is up for revision, and as such, we need to get ahead of it since we're revising this act currently. So I'm not in support of us ignoring it or leaving it be because of what is in the Defamation Act, unless you're telling me that we cannot do it based on something in law or in how law is practiced. But I do believe it is important now for us to address this issue.
Can we get a clarification on the last statement, or the last question that Member Rodriguez asked, which is whether or not there is something precluding you from including it.
Chairman, with all due respect, I think that clarification was given. I mean, I recall when we were drafting and tabling the Defamation Act in the 2010 around their time. This was an extensive discussion, the question of criminal libel, etc. And it was a policy decision taken consistent then as it is now with how the international community views this kind of law. The concern, though, that I think that Senator Rodriguez is raising is one that I think can quite adequately be captured under Section 9 or the proposed revision of Section 9, which is to come. So, as someone who was involved in the work on that piece of legislation and who has had to rely on this on act that was then promulgated and reviewed later, I would not be in support of us retracing our steps, as I think the evolution that led us to the abolishment of the criminal libel standard is one that is good and that we ought not to disturb.
Well, that was 2010. We're now 12 years ahead when cyber issues have taken on a whole new face and they change so rapidly. So what happens with pen and paper is different from what happens in the cyberspace, and as such, something what that was relevant 12 years ago may not be relevant now. So I don't think because we had that discussion 12 years ago, we should be held to it right now when we're dealing with a cyber matter.
That's not the basis of my objection, It's not the years that have passed. It's that I don't think the standard now would serve us any more than it had been determined it wasn't serving us then. And I think the concern that Senator has can be dealt with under Section 9. What is it about Section 9 that you think does not capture that concern?
Well, I would have to see the revised version of Section 9 in order to do that. So maybe if the revised section can capture it in such a way, but as written, I wouldn't have been comfortable, but I guess we can wait until then.
Member Green, I think that's a good point made in terms
Sure,
of
maybe you had asked legal reform to respond. So maybe I will await if they have anything else to add. Or maybe I should ask them just to restate the position so that I am clear to see if I really need to make an intervention. So maybe legal reform could just restate, just to ensure that I adequately heard the position that they were putting forward. Because I'm minded to share their view, but based on the conversation, I'm not sure if I was clear on what they said. So let me wait here from legal reform again. Sure.
Okay, so what we had essentially said was that when in our research, we found, as Member Golden Campbell mentioned, that the position internationally throughout the years and up until now is to repeal provisions for defamation. It's decriminalized. It's normally something that is treated within the civil sphere. And when the decision was taken to repeal criminal libel, that provision for criminal libel, it wasn't only applicable to the physical space, it was criminal libel simpliciter. So it would apply to cyber defamation as well. So it was repealed. So for you to, and it's a provision that's within that act, it's still a live provision. It has not, that provision, section 7, is not repealed. So for you to make a provision for cyber defamation, you're impliedly amending that provision, and that's not how the legislative process is normally conducted. You would need to make a change deliberately to the Defamation Act. And so if that is what the committee is minded to do, then I think the better course would be to recommend that that provision be repealed, or that provision be reconsidered, but not that provision be made for cyber defamation within this act.
Yeah, so here I will make my 2 points. One, I agree with legal reform. I do not believe that we should introduce cyber defamation through this bill that we're now reviewing. I think clearly there would be much wider policy considerations that it ought to more appropriately be dealt with in any review of the Defamation Act. So I agree with that position. That is one. Two, there is always a balance that is sometimes very hard to strike between freedom of speech and defamation. And clearly, I have seen that people do abuse freedom of speech rights on social media, and they do oftentimes say things that are very defamatory. Now, again, the direction that the majority of the world has moved in is that those things are really dealt with through personal civil remedies and not through national criminal remedies. So again, people do have a case if somebody has defamed them in the cyberspace, and they can find solace in our laws to be able to bring their own personal remedy matters. I'm not sure that I would agree that we should move to criminalizing the concept of defamation as it used to be. And instead, I much rather the position that these things have to be dealt with as civil remedies.
Again, Mr. Chairman, if I may, through you, I think it comes back down to the discussion that we were having earlier about public education campaign. So about public education campaign and the responsibility of the government as well to the nation, especially as we move towards a digital society. Because the truth is, as legislators and as key stakeholders in the direction in which the country goes, we tend to take things for granted, based on our knowledge base. So even going back to what one member said earlier about, the very trite principles of law and ignorance of the law is no defense, etc. I do believe that as we move forward with becoming a digital society, that we do have a responsibility to have an ongoing educational campaign about, use of social media, responsible use of it, defamation, what constitutes defamation, that retweeting, reposting, retelling a story, whether it's Instagram, Snapchat, the WhatsApp, etc., that it's all a part of a larger civil wrong or criminal wrong, depending on what the information that's being forwarded, so that every Jamaican understands, including the 12-year-olds who are on the various social media platforms, that every single person understands that, listen, this is wrong. It can either be a civil offense or it can be a criminal offense. Don't forward, delete, report, whatever. Whatever the slogan is coming out of that. But certainly, I believe that public education campaign would take care of much of the concerns of Senator Rodriguez and also the points raised by Member Green and Golden and the Law Reform Department as well.
Chairman, can I just intervene here? The discussion we're having came up the last time we reviewed the Cybercrimes Act about maybe 2015, 2016. And we didn't include defamation, really based on the reasons articulated by Member Green just now, that there are remedies in other legislation to deal with people who defame you, and that we were not seeking to criminalize that through the cybercrimes legislation. And really, defamation is defamation, whether somebody stands in half a tree square or whether they go on social media and defame you. And I think we should maintain that. I do support what Member Terry Long has said about ensuring that there is public education, because there are people who have a view that there are different rules that apply in the online world versus what applies in the physical world. And it would be beneficial for people to know. But I certainly am very strongly of the view that we should not make any attempt to criminalize defamation in the Cybercrimes Act.
Noted, member.
Chairman, may I come in?
Go ahead.
Thank you, Chair. Good morning and good afternoon. Good morning to everyone. Just a little note around the proposed public education campaign as brought up by by Member Terrelong. You know, one of the key things that I think that we need to emphasize there is the role of parenting, especially in the cyber space. You know, when it comes on to social media presence, we have a tendency, and especially our children, to be controlled by social media rather than recognizing that it is a tool, an instrument, an accessory to our lives. And just as parents ought to guide children in all aspects of development, we need to recognize that this virtual world is the new existence for children. There is a role and responsibility for parents to guide their children as to how to navigate the cyberspace, just as you would see to their education otherwise. It is critical for us to bring that message and to almost recognize whether or not there is, I don't know if penalties, if there's a repeat situation where a child is exposed in some way and it is brought to the attention of the authorities and it is not addressed on the part of the parents. I think that we need to ensure as best see to that parent knowing their responsibilities in ensuring their child safely online. Just want to add that, and specifically as we contemplate PR campaigns around this issue. Thank you, Chair.
Come on. May I?
Yeah, member, go ahead.
Right. So there are many times when we are reviewing a legislation and we recognize the dependence of another piece of legislation. And this is the moment now when we are recognizing the dependence of the Defamation Act that would have been passed in 2013 and due for review in 2018 and become more relevant in terms of the demand today. And you know, one of the things we must always assure is that when the time frame comes for legislations to be reviewed, we must religiously stick to those time frames. And there is a recommendation today that the committee could consider recommending that a JC be appointed as soon as possible to review this act. And I believe we must agree on that and take that as a position, as a recommendation going forward. Coming out of this committee, based on what would have been discussed today, it is more relevant than it could ever be, because there are a number of persons who hide behind social media and attack individuals' integrity. And I believe we must agree that that piece of legislation is to be reviewed. Thank you, Chair.
Mr. Chairman, I just want to say I hear what all my colleagues have said. I do hear what everyone has said, but I still maintain my position, and I know it's a majority, so my position will not hold, but I need the records to reflect that. The argument that it can be handled at the civil matter has to be taken within a cultural context. Jamaicans do not, on the regular, go and file a civil case. Only the wealthy in Jamaica file civil cases, and I stand to be corrected by the attorneys here. But civil matters are not something that the average Jamaicans can afford to undertake or that they choose to undertake because of cultural practices. And I still maintain that as legislators, we have a responsibility to protect the majority of our people. And by saying that this matter can be handled at the civil level is not enough in my mind. But I do understand that the majority of my colleagues believe that this issue can be handled at the civil level instead of as a criminal matter. And so I will accept the majority's decision, but I am totally against it.
Noted, member. Thank you for your contribution.
I would also say, Mr. Chairman, although I believe I was in cabinet when we made that decision to move defamation outside of the criminal sphere, the unusual feature of the what you would call it, maybe the cyber defamation or the anonymity that cyber offers to the person who is committing the defamatory offense makes it extremely difficult and expensive for a civil litigation to proceed. I usually just to retain an attorney in a case like this is going to require a retainer fee of $800,000 to $1 million. And then there are cyber experts, et cetera. So for all intents and purposes, it is beyond 99% of the population, even if they were so inclined to pursue it. So I don't know.
I believe I'm agreeing with Senator Bunting. We find a mutual ground of agreement.
Well, I too had to.
Or he's agreeing with you.
I too had to wonder if I should reconsider my position if it coincided with yours. But in this case, I have thought carefully on it, and it does, as I say, for all practical purposes, it leaves no recourse to the average person. And I'm wondering whether we, again, as Senator Gale said in the recommendation for the review, if we could make a special, carve out for the cyber defamation, the cyber type defamation, to create an exception there, because it effectively excludes the average person from having a recourse in the civil courts.
Noted, Member Bunting, and I think both yourself and Member Rodriguez, and from someone who has experience in terms of this particular situation, it is real, and the fact of the matter is that it is a major hindrance in terms of getting justice and the cost of it, etc. Adrian, go ahead.
Thank you very much, Chairman and members. The next issue that was raised was the concern that there should be...
Oh, sorry, before we move on, are you moving on? If we're moving on, what have we agreed to? I don't think we can move on until we have agreed.
I think, member, by virtue of what your statement earlier in relation to the majority, I thought that was a given based on the comments that were made. I mean, outside of yourself, a member, but I haven't heard anybody else support the position. So obviously, as you said before, the majority position would hold.
Mr. Chairman, everybody who is in here who has a vote, I don't think they've spoken on the issue. So can we probably vote on the issue? Because I think this is anything that locks out the majority of Jamaicans is not a good look, Mr. Chairman. And we would be locking out the majority of Jamaicans affected by this. And it is expensive. There are those amongst us who have had to go through it through as a civil matter, and they can attest to how expensive it is. So we're saying no recourse for the typical Jamaican. We're only going to facilitate wealthy Jamaicans if we go along this route. And I feel very strongly about it and ask Mr. Chairman if we can vote on it.
I would intervene. The framing of this matter in relation to affordability for recourse, and that if defamation isn't criminal, then you would not be able to allow the majority of Jamaicans to have a recourse. I do not agree with. And again, we have to be very careful sometimes the principles we undermine. Remember, there is a principle about the right to free speech that all Jamaicans appreciate, that we as politicians, even though it's very difficult, sometimes we're lambasted by our contemporaries, the ordinary Jamaicans, all right? And if it reaches to the level of defamation, the question is, should you have a right to that person being imprisoned because of what they said about you? Or should that right be that the damage that was occasioned upon you, that you suffered, that you can rightfully get back? So one, I have a number of matters. I've seen a number of matters in my time where regular day-to-day Jamaicans having arguments in their regular community, and the argument escalates, and one person makes an accusation about the other person that would lower their impression in the mind of right-thinking individuals, and the two of them end up in court. The two of them end up in the parish court for a matter of defamation. Do not believe that Jamaicans are unaware of their rights in this regard. And I've seen them come into the office and say, boy, Mr. Green, the person called me such and such, and it's not true. And so much people here. And I have people who are willing to go court, and them go court. Now, I do take the point that with cyber matters, this is more difficult because people hide behind a lot of barriers that you have to oftentimes get experts. But what we're saying is that now the government would undertake the pursuit of these matters on behalf of the citizen, when I cannot say that I believe that the matter is criminal. So it really starts from whether you are of the view that if somebody says something about it that's not true, which lowers, and again, almost all of us have been the subject of this, that lowers your estimation and that causes reputational damage and that causes loss to your business, whether that is a criminal offense or whether that has to be dealt with differently. I'm saying I do not believe that it is an offense that should be criminalized. And that helps ordinary Jamaicans who could find themselves on the wrong side of the law being taken into custody for something that they said that is considered defamatory.
So, Chairman, if I may, I'm agreeing a lot with Member Green on this. And as much as I've heard Member Campbell Rodriguez and Member Bunting, I also feel very strongly it should not be criminalized. And we have seen examples across the world, and I can do the research and show you where when it is criminalized, that overreaching governments in particular use it as a means of silencing people who are legitimately opposed, people who are involved in human rights, etc. So while I take the point about the cost of pursuing cases and seeking a civil remedy, I also feel very strongly it should not be criminalized because it is very susceptible to abuse. And I can speak of other cases where law enforcement has been used in a way to intimidate people. And if we criminalize this, people will be locked up and then have to go through hire lawyers to prove their innocence. I think, as Member Gale said, let us deal with the Defamation Act, where that needs to be strengthened, where that needs to be reformed, let's do it. But I feel very strongly against seeking to criminalize in this legislation. And as I said, we also had this discussion about 5 or 6 years ago when we did the review of the legislation, and having looked around the world at best practices, we decided not to criminalize it.
So we have heard once again from Member Green and Member Robinson. There are some persons that have not come into the usual practices that if you have not said anything, then obviously then that is silent agreement. Is there anybody else?
Yeah, and no, but I just like to clarify my position, Mr. Chairman. I wasn't saying that it should be criminalized. But I'm saying I understand and very sympathetic to the point Member Campbell Rodriguez was making, and I'm adding my voice to Senator Gale's own, that we should urgently review the Defamation Act to see whether there may not be some carve-out or special mechanism put in place to make it easier to pursue such a case in the case of cyber defamation or defamation using a cyber shield or anonymous or pseudonyms in social media, etc.
Thank you, Member Bunting, for the clarification. All right, so Member Rodriguez wanted to be assured that the position that was stated, which she was against, was favorably considered by the majority of the membership. So as I said before, usually if one doesn't raise an issue, an objection, then obviously the silence is consent. Is there any member that would want to say anything further on this matter? And if you don't, then obviously you would agree for it to remain as is. All right, so Member Rodriguez, that satisfies your concern.
I so believe in democracy that of course I will go with the majority view.
And your comments will be noted. So you will
yes, please.
There. All right. Katie, and go ahead. Member Gale, just chair for 2 seconds for me again. Let me just walk out to deal with some. Thanks. Right.
Thank you very much, Chairman.
Go ahead, Katie.
Thank you very much. We're going to move now to the concern that was raised in relation to a new offense of cyber threats. And I'm going to again defer to the LRD to speak to this particular concern. And members will note in the matrix.
For ease of flow, can you just indicate the page you are now?
I apologize, I planned to that. I'm on page 25.
Ah, got you.
Right. Members will note in the comments of in the analysis and recommendation that section 9 again is played. And if the members are minded, there is in fact a preliminary draft of section 9 that can be shared and members can look at it, or members can determine if we want to look at it at the end of the meeting. So LRD, you may lead on this particular concern of cyber threats.
Okay, so what our research revealed was that in most jurisdictions, cyber threats are addressed through the provision made for malicious communication, similar to our Section 9. We think that Section 9 does cover the issue. We do understand the limitations that the section poses at present, and we think that if it's revived, it would definitely more adequately address the issue of cyber threats. We also note that the issue of threats is handled in 2 other pieces of legislation that could be, that we recommend could be amended. The Towns and Communities Act makes a provision for using threatening, abusive, calumnious language. That section, we think though, the penalty under that section, there is no imprisonment, so it would not be prosecuted, could not be prosecuted as a cybercrime. And so we recommend amending that section so that a penalty of at least a year is imposed so that it could be prosecuted under Section 4. There's also the offense of sending letters to threaten murder under the Offenses Against the Persons Act. We think that the provision could be amended to make it more technologically neutral, and in that way, this offense could be prosecuted as a cybercrime as well.
Is it possible that the 2 references, the 2 reference legislations, if they could be sent to us just for context, so we can align better understanding in terms of what is being recommended for the next meeting?
Member Gail, I'm going to ask you, can you just repeat that? I had some connectivity challenges.
Right.
I didn't clear.
So LRD, you would have made references to 2 pieces of legislations that we may consider strengthening, but just for context, if the wording of the areas of those 2 legislations could be just sent to the committee, so in order to bring context to the discussion.
We could certainly do that, but what I could also do in the interim is that I could also seek to have the particular sections brought up on the screen, and perhaps I could assist.
That is even better.
Okay, so I am going to then ask member, with your permission, if we could just defer consideration of this particular area. Let me take the issue of spamming, which the ministry lead on, and then we could go back, we could take another section and then go and look for those sections.
Yeah,
and with the
that's fine.
All right. So with your permission, I'll move to the matter of spamming. Again, spamming, a specific offense in relation to spamming was recommended. As indicated in our matrix, spamming speaks to the abuse of electronic messaging systems to basically send unsolicited bulk messages to various recipients. Spamming can also be a method by which information is shared, but then also a method by which computer viruses are also introduced into computer system, Trojan horses, or other types of malware. And it can also be used as a means of facilitating identity theft. When it is that the ministry looked at this issue of spamming, we looked at not only international references, but we also looked at what actually is the compendium of legislation that we have currently to deal with this issue. So I'll start off first by noting that our research revealed that where there's no specific legislation regarding spamming, or no specific provisions in cybercrime legislation that deals with spamming, that countries tend to deal with this issue either via their electronic communications legislation, their telecoms legislation, or via their data protection legislation. When we look at our legislation, we note that our Electronic Transactions Act currently covers issues that relate to spamming and particular issues of spamming. Section 29 actually speaks to the offense where someone actually sends unsolicited commercial communications. It speaks to how it is that you are supposed to deal with that. And then it goes on to indicate that if you continue so to do, when a consumer has indicated that he or she is no longer desirous of receiving that communication, that an offense is in fact created. When we looked at how it is that commercial communication is actually defined, it speaks to communication which offers either gives. It speaks to communication which essentially either offers something for sale, for hire, or for exchange. And the legislation right now actually speaks to the penalty, which is a fine not exceeding $1 million or imprisonment, where it is that the conviction takes place in a parish court, and then to a fine or imprisonment of a higher term where the conviction takes place in a circuit court. We also know that our data protection legislation, which was enacted, or which was, passed in 2020, also spoke to this issue of spamming through the use of the context of direct marketing. And this was a subject of debate a lot when we were dealing with the data protection legislation. And so the legislation there actually indicates that prevents, the use of personal data for the purpose of direct marketing unless there is specific consent on the part of the data subject. Or, as we note as a carve-out that was requested at the time, you are a prior consumer of the data controller. And so our section 10 actually speaks to that. Now, it is also noted that if and that's perhaps speaking to instances where you're trying to send commercial communication. Recall that I had mentioned earlier that spamming can speak to the gamut, both commercial communication as well as introducing malicious software or malicious activity to somebody's computer. So to the extent that it's commercial communication, we are of the view that our Electronic Transactions Act and our data protection legislation adequately covers the issue of spamming. Where it is that the actual spam or the content of the spam actually does something illicit or causes some type of damage or harm, we believe that the cybercrimes legislation, or we recommend to the committee for consideration that the existing cybercrime legislation can address some of those issues. So where the spam contains malware, which has the following effects, then the existing sections already deal with them. So if the spam or the malware allows access or enables access to a computer system, then our section 3 already deals with that. If the spam actually causes illegal interception or enables the illegal interception of data of communication, in relation to a computer or transmissions of computer data, which is a word which is there, then our section 6 deals with that. If the spam actually causes some kind of damage or deletion or some sort of, or interferes with some of the function of a computer system, then our sections 5 to 7 actually speak to or deal with that. Additionally, if spam messages contain devices that are designed, and we already have that long discussion about something being designed or adapted primarily for the purpose of committing offenses, we already looked at that under section 10, then we also believe that that could also be covered. And so what we're saying to the committee is that the compendium of certainly our understanding of the way in which spam messages currently occur, the type of spam messages, that are out there, that currently our legislation vis-a-vis the Electronic Transactions Act, the Data Protection Act, and the existing sections of the Cybercrimes Act adequately cover this particular area, and to seek to have a discrete provision that speaks specifically to spamming would not be something that we'd recommend for the committee's consideration at this time, or consideration period.
Any comments, colleagues?
Mr. Chairman, I think our discussion this morning about the different types of phishing, I think when I would be able to better, I think when we get that information from the team describing the different things, because I'm not sure how, in my mind, in my untrained cybersecurity mind, spamming is sort of in the same category and stand to be corrected. I think when we get that information, we can really see if it is covered, although I'm prone to agree that it is covered, but I just want to err on the side of caution. Unless, of course, one of the technical persons can say to me that spamming is in no way connected to those other issues we discussed this morning.
And then, but just to be clear, that you're asking if we can clarify if spamming is in no way related to phishing, ishing, smishing, and those that were spoken to earlier?
Yes.
Perhaps I'd want to defer to Lieutenant Colonel Sterling to provide a distinction and see if that can assist you in making that determination. Lieutenant Colonel Sterling.
Thank you.
Colonel?
Good morning again. So by the classic definition of the ishings is the fraudulent or fraudulent attempt or masquerading as a legitimate entity while soliciting identity information or personally identifiable information with the view to further commit a cybercrime or enable the commission of a crime using cybersecurity, using cyberspace and ICT resources. Now, spamming is really unsolicited messages sent to you. In its puristic form, it is really just a lot of clutter in your mailbox that you really don't need. It's quite similar to what telemarketers would do. In its malicious form, it sometimes has embedded in it, sometimes disguised as reasonably safe links or attachments, malware that seek to cause other forms of access to be enabled or actions to be carried out. And so the pure definition of the two sets of events would seek to separate them. However, the creativity that exists would seek to ensure that the ishings, if I may borrow that term from Member Rodriguez Campbell, are really malicious in intent, whereas spamming sometimes it's a very difficult thing to separate it from just mass mailings from telemarketers. And so to criminalize it without the additional modification of adding malware or having malicious links or links to URLs that are malicious is really what separates the two. And so they're not the same, though if maliciously tampered with, spam email can actually lead to not only denial of service, given the volume that your mail server has to deal with, but also compromises that are triggered by clicking on links or opening attachments that have malicious components in them.
So, Mr. Chairman, following on what, I'll say, Mr. Sterling, what's your correct title?
Lieutenant,
what should we refer to you as?
Lieutenant Colonel or Colonel, ma'am.
Okay, all right. So Colonel Sterling, based on what you have said, I just want to confirm if the legislation as written would cover instances where a spam email is used to do an ish.
It would, ma'am. It
would? Okay. Then I support what the team is suggesting then.
All it would require is that transition to the ish be identified in a provable way, and then it's a simple case of using sections 3, 6, or 7. Yeah.
Thank you so much, Colonel.
You're welcome.
Thank you, Colonel. Mrs. Newton-Smith, just for clarity, you made reference to 2 other pieces of legislation that support spamming, the Electronic Transaction Act of 2007, and I recall the the heavy debate we had in the Data Protection Act, I'm trying to think back around our Telecommunications Act, whether or not there are inferences that would have supported spamming in that piece of legislation.
I can't recall at this time, Senator, that our Telecommunications Act deals specifically with spamming in the manner that the electronic transactions and data protection deals with it. What I was sharing earlier was that, that when we did our research, we found that countries that didn't have discrete provisions to deal with spamming in a cybercrimes legislation sought to deal with it in 3 ways: through electronic transactions, telecoms, or data protection. And
Okay.
I call in our sphere that we have chosen electronic transactions and data protection as a means to do it.
All right, thanks. So the next area would be.
If I may though,
Yeah,
Chair,
sure.
you did ask us to perhaps go back to 2 sections. So just to indicate that my colleagues at the LRD would have made references to 2 pieces of legislation that they would have found in their research: the Town and Communities Act, Section 3M, as well as Section 18 of the Offences Against the Persons Act. And you had asked me to make, you've asked me to share those particular sections as well, Section 3M and 18, which addresses threats. With your permission, I could share my screen and I could share those.
Please.
So you should be seeing on screen Section 18 of the Offences Against the Persons Act. I believe this is a section that was spoken to. I don't know if I needed to read it, but it says, whoever shall maliciously send, deliver, or utter, or directly or indirectly cause to be received, knowing the contents thereof, any letter or writing, threatening to kill or murder any person, shall be guilty of felony, and being convicted thereof shall be liable to be imprisoned for a term not exceeding 10 years with or without hard labor.
Right.
And with respect to the Town and Communities Act, Section 3, subsection M says, and the chapeau, my apologies, I should have indicated, the open chapeau speaks about every person, and it says every person who, and going to M now, shall use any threatening or abusive and calumnious language to any other person publicly, as shall tend to provoke a breach of the peace, or shall use such language accompanied by such behavior to any person publicly as shall tend to a breach of the peace, shall tend to a breach of the peace. Continuing about the commission of offense.
Sorry, can I see the chapeau?
Sure. It says every person who. It says every person who. Every person who does the things in M, I'm just showing you what M says again, uses threatening or abusive or calumnious language in such a manner as to tend to provoke a breach of the peace, or if they use a language accompanied by behavior which tends to a breach of the peace, commits an offense. I'm going to that particular section now, and shall be guilty or liable, to a penalty not exceeding $1,000. So you will recall that one of the things that our colleagues from the LRD would have indicated was that was not my apologies. Would you like me to stop sharing now, or would you like to still look at it?
That's fine. That's fine. Okay. So what LRD had indicated is that we were to make the consequential changes, make it more modern and technological supportive, in essence.
That's correct.
All right. All right, thanks for that. So we know.
So I'm sorry, Chairman. I don't know what's the committee's position in relation to cyber threats, having heard what it is that LRD would have shared. I believe LRD was indicating in its recommendation that there is no need, or there is no need essentially for the Cybercrimes Act to make a very specific provision for cyber threats.
Members?
I agree with the recommendation by the technical people.
Yeah, I agree with it too. I think there's always a temptation to try and put a number of what we deem offenses under this particular legislation, particularly where there may be other legislation which can adequately cover it. So I support what LRD has said.
Thanks, members. I see LRD indicating that they want to respond. Go ahead.
We just wanted to clarify that with regards to the other two pieces of legislation, it's not that we would be making a consequential amendment, because those two legislations do not fall within the remit of MSET. So what it would be is a recommendation that the appropriate ministry make those amendments.
Right, I got that from it.
Okay.
But thanks for that reinforcement. Mrs. Member Green?
Yeah, there's a question. If there's a need for an amendment in that regard, why wouldn't we deal with it here?
I think though, in my mind, having examined it and having taken the recommendation, when we are submitting our report as a committee, we may want to indicate our recommendation towards such.
Yeah, but I'm saying it is a matter that could fall directly on our remit.
In terms of this piece of legislation?
Cybercrimes, yes. In other words, it would not be a far reach for cyber threat to be dealt with under the Cybercrimes bill.
Mm-hmm.
I get the impression that what we're saying is that there are pieces of legislation to which you could fit a cyber threat so that you could have recourse, but we probably should ask them to amend it to specifically speak to a cyber threat. And I'm saying once we have to go down that road, why wouldn't we just treat with it in this legislation?
You know, Member Green, one of the things that always grapple me in doing these reviews of legislation is whether or not, having identified the challenge, whether or not we can make our own amendments to the legislations under review.
No, if I may, though, Chair, and LRD would have spoken to you, but I'll just reiterate the point that was made earlier. So I understand Member Green's concern. Recall though what was being indicated, and I'm not sure if it is that it wasn't we didn't as a team articulate it as clearly. But what was being indicated was that Section 9 of our legislation currently could address issues of cyber threat, because that section speaks right now to malicious communication. And there's a proposed amendment to that to address, which would augment even our position on that particular situation. Notwithstanding, we're also saying that there is existing legislation right now in relation to the Town and Communities Act, as well as the Offences Against the Persons Act, which address the concept of threats generally, for which cyber threats would just be a subset essentially at this time. What the LRD is recommending is that the legislation could actually be both the OPA and the TCA could actually be amended to consider modern technological methods by which threats would occur. But because threats don't only occur in the cyber realm, it would not be within the remit of this committee, which is specifically set up to look at the review of the Cybercrimes legislation. And in a context where the Town and Communities Act and the Offences Against the Persons Act would not fall squarely within the remit of the review, and as LRD indicated, would not be consequential amendments, we could not say that those amendments could be made by this committee, recommended by this committee, or would be consequential, but rather the committee could consider indicating to the responsible ministries that amendments be made to those pieces of legislation to ensure that across the gamut of the legal framework, cyber threats are addressed in a like manner. And that's the recommendation that we were putting on the table for the committee to leave with and to put to those ministries, that those pieces of legislation be amended.
So Chair, I agree with the second half in relation to definitely making those recommendations that the amendments be taken to treat with, using these modern technologies to communicate threats. And I get that. I'm more heartened by ensuring that in any review of Section 9, that the concept of a cyber threat is clearly, in other words, I do believe that in the case of cyber threats, you must be able, it is a cybercrime and you must be able to appropriately place it under the Cybercrimes Bill Act. So if that is what we're saying, is that you do believe that Section 9 already captures it in relation to malicious communication, but in our review of Section 9, we can look to make it stronger to ensure that there's no doubt that it captures cyber threats. Then I'm okay with that, Chair.
All right, thanks for that, Member Green. Mrs. Newton-Smith, where are we now?
Thank you for that. Oh, my apologies. Thank you for that, Chair. And we have taken note of the members' comment in relation to Section 9. I had indicated earlier, Chair, that there is a current preliminary draft of Section 9 that I believe my colleagues at the LRD would have liked to perhaps speak to. So I don't know if it's an appropriate time to take it now, or if the chair would prefer, given the time and given that this issue Section 9 has been raised again here, if this is another matter to be taken at the next sitting of the committee.
My suggestion would be to take it at the next sitting, because I'm sure when we examine what is going to be proposed, it may lead to another extensive debate, given the concerns raised in regards to this. So that would be what I would be suggesting at this time.
Noted, Chair.
So I'm only substituting as chair. Is the chair returning so that we can?
I'm back. Sorry.
Thank you, Chair.
I was listening, but I didn't turn back on my video. Sorry about that.
So over to you now, sir.
But you're over to me at 12:05.
Right.
So I think basically we have at 2 o'clock. I have another 2 o'clock, and of course the staff. So I think basically where you have reached there today, is there anything that you want to conclude before we close off, or if you reach a point where we can close off based on?
I believe we reach a point where we can close off, sir. And we look forward to the next meeting where we will, receive the proposal in regard to Section 9 that would have generated much discussions. And I anticipate that is going to generate some further discussions at the next meeting.
Right, and also we're supposed to get something from Ministry of National Security. So, Kadian, can you tell us whether we'll have that for the next meeting, or it's going to require more time?
I'm sorry, Minister. No, we will not. My understanding is that what the approach is to take all of the concerns, to go through the matrix, taking all of the concerns that may have been raised. And then we're going to sit and have a meeting with all the technical persons from National Security, DPP, MOCA, and have one discussion essentially in relation to all of the concerns that have been raised by the committee. And then we're going to revert to the committee in relation to their responses on the matters that have been asked for clarity or the matters that we've been asked to confirm.
Chair, can I ask if there's a determined date for that meeting?
Not as yet.
Not as yet. Okay.
Through you, Chair, to the member, not as yet.
Okay.
Well, based on what I'm seeing here, the next proposed meeting date is the 23rd of June at 10 a.m. So basically, if we could get Section 9 circulated ahead of that, so that persons would be able to read and of course be able to prepare themselves for the for the next meeting. That would be useful.
Yes, Minister. I have received permission to share Section 9 draft, and I have done so. I've shared it with Ms. Brandon.
Excellent, excellent, excellent. All right, so the Thursday, the 23rd of June at 10 a.m. Members, any issue with that? All right. All right, thank you to the MZ team. And of course, to the members and supporting staff of the various ministries and agencies. And we will adjourn until Thursday, the 23rd of June at 10 a.m. Until then, everybody keep safe and we meet again. Thank you very much.
Thank you, Mr. Chairman.
Bye, colleagues.
What a way you're full of our roots and culture. That was in Jamaica 60. Jamaica 60? What a piece of news, Mr.